يسمم يسمم. Thank you, Dr. Madhumita, for the introduction. Hope my voice is audible, right?
Yes, ma'am.
Okay, thank you. Thank you, thank you. If it is not audible, please let me know. We'll change it. That's why. I think we can go ahead with the session. Ma'am, could you please share the slides? Or do you have anything from your end to be conveyed? Anything else about the session if you have from your end you want to convey? Okay, okay, thank you. Right. Let us now go ahead with the session which is planned today. First of all, first, good evening to all. So I take this opportunity to welcome all the participants from Bishop Eber College on behalf of Team DEX for this webinar on basics of IPR and patents. So hi everybody. Uh, so before getting into the session, few things I would like to share from the end of DEX patent. Over to the next slide. Ma'am, could you change the slide, please? Yeah, thank you. As I mentioned, just it is a quick intro about our DEX patent, who we are and what we have been doing this more than a decade in Trichy and what are our services. So first is DEX patent is an intellectual property research and patent analytics company, and we have been meeting the needs of global professional and academic customers. Apart from this, we have been in this field for more than a decade, adding values to many Fortune 500 companies, large law firms, university technology departments, and startups for creating IP and also protecting it. We are actually a one-stop shop for all the patent services, and we have offices in India, US, UK, and UAE. So this is a quick intro about DEX patent and what we do. Next, next slide, ma'am, please. Yes, this is just a formal request from our end. Most people would have been familiar with this whenever you attend any webinar. So questions will be taken up towards the end of the webinar or during webinar as it is appropriate. So if you feel that if you have missed your chance to ask any questions or you need something to be dealt in detail, so then you can definitely write to us in the email ID which you see here. There's info@dexpatent.com. So this is a quick request from our end. Hope it is clear. So moving on to the next slide. So this is again a quick intro about both of us. As Dr. Madhumita has already gave a quick intro about both of us, but still, again, one more a quick intro from our side. So my name is Bhargavi Krishnan, and I am working as a senior patent scientist at DEX Patent for more than 5+ years. So my area of expertise is electrical and electronics, and key focus areas, that is the services which DEX provides to the other companies, which the ones which I support is primarily patent searches, patent drafting, that is drafting patent applications, and prosecution support. So this is a quick intro from my end. Over to Jaya. She will be accompanying me in this session. Ma'am, please go to the previous slide. Jaya will give a quick intro from her end. Jaya can give a quick intro.
Yes, Bhargavi, thank you. Team, hope my voice is audible. So, a great good evening to one and all. So, I am Jayalakshmi Gopalakrishnan. I am a senior patent scientist at DEX Patent, and I have expertise in electronics and communications. Currently, I'm focusing on key areas like drafting patent applications and handling patent prosecution. So that's it for now. Over to Bhargavi for the first half of the session. Thank you, Bhargavi. Thank you.
Thank you, Jaya. Next slide, ma'am, please. So So this is the agenda for today's session. If you see, the first one is introduction to IPR and its classification. So in that we will be seeing what is meant by IPR and what are the types of IPR. The next one is overview of patents. So in different types of IPR, you will be seeing the details about patents. And the next is, if you want to get patent, what is the patentability criteria? What is the criteria that your invention has to satisfy? So that will be the third one. And the fourth is nothing but what are inventions and what are not inventions. We may come up with many inventions, but can we call each and everything that we come up as an invention? That is one doubt among many people. So in that you will be seeing what are the things that is called an invention, what is not called an invention. That is the fourth one. And the fifth one is overview of patent filing, how to file a patent in general. So what are the steps? That will be covered in overview of patent filing. Apart from this, regarding the session, if you have any queries, which will be dealt at the end of the session. So this is a quick agenda for today's webinar. Over to the next slide. Yes. So let us now get into the session. Introduction to IPR. So just want to ask one question. If you have any idea about IPR, can share any basic idea, or at least what is the term IPR stands for? Any idea from your end? People have any idea, or just a basic abbreviation about what is IPR? If you know, means we can you can share. Else we can get into that. So I assume that no idea from your end. Can I? So let me proceed with that. So IPR is nothing but it stands for intellectual property rights. So IPR is just an exclusive legal right which protects the creations or inventions, which is a result of any intellectual activity in any field, like industry. It can be your intellectual activity can be in any industrial field, or it can be in scientific, or it can be literary or artistic fields, or any other fields. And you need to protect that particular activity, so you need a legal right. So whenever it is a legal right, it has a lot of validity. So such a right is nothing but the intellectual property right. It is not actually for lifetime, it is only valid for a certain period of time. So that time period varies from each and every type of IPR for which you are seeking protection. So it varies for if it is for
these criteria are. Moving on to the next slide. Yes. So the first foremost criteria is a novelty. What is actually a novelty means? It is an invention or technology. I mean, your invention or technology should be new and original. It should not exist elsewhere in the world before you are filing a patent. So an invention can be considered as novel when it is different in maybe in one of its important or essential elements from all other previous inventions, which is we typically call it as prior art. So this is the this means novelty. So moving on to the next slide. The next criteria is inventive step. So the inventive step means it is a new technical advancement in the feature of an invention, which is called as inventive step. The technical advancement should be new when compared with the existing knowledge, and it should have economic value. So the advancement of the invention should not be known to a person who is skilled in the specific field. Maybe you can see in the right corner image. So for example, telephone is a new idea which we all know, which obtained patent in its earlier days. The evolution of telephone, right from telephone from smartphone, also got patented because they have satisfied the inventive step criteria. Moving on to the next slide. The final criteria is industrial applicability. Any invention or idea should be in its useful form. So your invention should be capable of being made, or it should be used in the industry. Also, it should fix the problem existing in the environment. So as you can see in the image, a spectacle with a single lens is of no use to the consumer. Also, a bended spoon is also is of no use to the consumer. So any invention should be useful to the public. Moving on to the next slide. So let us see what are all known as inventions. Okay, an invention can be a process or it can be steps in methods or making steel or a preparation of chemical compounds. Moving on to the next slide. Yes, yeah, your invention can also be a machine or a device or an apparatus for doing its operation. For example, air purifier, scanner, gaming console, wireless chargers, sieving machines, etc. Moving on to the next slide. Yes, your invention can also be a composition of matter. That is, it can be a mixture of one or more substances such as gases, fluids, powders, or solids. Examples can be toothpaste, creams, nail polish, medicines, etc. Moving on to the next slide. So the next, your invention can be an article. Article in the sense, the devices that do not have any moving internal parts. Examples can be chairs, gloves, shoes, and mouse pads, etc. Moving on to the next slide. Yes, now that you'll be familiar with what are known as inventions, now let's take a look on inventions that are not patentable in India. Few inventions are not actually patentable in India. The first one is any natural laws are not patented. I mean, it cannot be patented. Example, Newton's law of conservation cannot be patented. Next is any mere discovery of scientific principle or the formulation of abstract theory is also non-patentable. Example can be the property of a known material to able to withstand the shock or a mechanical shock is a discovery and therefore not patentable. And next is plants and animals in whole part thereof are not patentable, but the microorganisms can be patentable. Next is biological process like photosynthesis, DNA replication are also not patentable. And any invention that is harmful and which cause injuries to public is also not patentable. And next is topography of integrated circuits is also not patentable. Next, any literary or artistic works are not patentable because they can be protected under copyrights. Next is any traditional knowledge which we follow for years, which we all know for several years, is also not patentable. Example is we all know that turmeric is antiseptic and neem is an antibiotic. It cannot be patented. And next is method or steps of surgical operations are also not patentable. Moving on to the next slide. Yes. Now that you will be clear with what are the patentable subject matter and what cannot be patented, so we can go ahead with the quick quiz. So from the picture, can you guess which one is patentable and which is not? The person who knows the answer can unmute themselves and can tell the answer, or they can post the answers in the chat box. Okay. I guess.
Ma'am, I
Okay.
think it's second one. Ma'am.
Sorry.
Second one. Ma'am.
First one is.
Second one. Ma'am.
Sorry, you're not audible. You're not clear.
I think, ma'am, it's second one.
Actually, the first image is deals with method of doing surgery, which cannot be patented. It is actually a non-patentable invention. And second one is it is an agricultural equipment which can be patented. And the third one is a method of producing mushrooms, which is not patentable. Okay. Yes, second one is patentable, correct. Fourth one is sieving machine, which can be patentable. And fifth is DNA replication. Yes, fourth is also patentable. It relates to a machine. And fifth is DNA replication. It cannot be patented, but any genetically modified microorganisms can be patented. Sixth one is method of playing chess. It is also not patentable. Yes, moving on to the next slide. Now let's see how an idea can be converted into patent. So if a person has a novel or a new idea, he can submit his idea to IP professionals by signing a non-disclosure agreement, which is called as NDA. If the idea is found to be not patentable, then he needs to improve his idea. In case if the idea is patentable, then he can file a patent application. The idea is in early stage. If the inventor or an applicant needs some time to develop the invention, then he can go ahead with filing a provisional application. In this case, the patent office will give a time period of 12 months to file for the complete specification. On the other hand, if the applicant or the inventor has a full idea, the invention is fully developed, then the complete idea of the invention, then he can go ahead with filing the complete specification. So the complete specification of the invention, after filing, it will be published automatically. It will be disclosed with the public within 18 months from the filing date. So after the arrival of the invention to the public domain, if any other person has a same idea, any other person has a patent for the same idea, then he can oppose the inventor. In this case, early publication of the invention is also possible, where your upon request, where your invention, where your application will be published within 1 month. 1 month time period after filing the request. So moving on to the next slide. Next step is to file the request for the examination. So after filing the application, in case the early publication request is not done, within 18 months, the application will be published in Patent Office Journal. So next step is to file a request for the examination. Then upon request, the patent examiner examines the patent application and determines the patentability requirement. So in that case, the examiner checks for the patentability criteria. Whether the criteria for the patent is satisfied and it meets the all the other requirements like clarity, conciseness, etc. So if the patent application is not objected, then the patent will be granted. In case the patent application has objection, the examiner will list out all the objection as first examination report, and it will be sent to the applicant. Then the applicant should file the response to the objections given in the first examination report within the time period of 6 months. Within the time period of 6 months. If not, then the patent application will be abandoned. Nowadays, there can be up to 1 to 2 office actions for an application based on its patentability. After that, an opportunity of hearing will be provided by the patent controller. So, where the applicant or his patent agent can explain the reasons for the patent to be granted through video conferencing. So in the hearing, if the response did not satisfy the objection, the patent application will be rejected. On the other hand, if the response is found to be satisfactory to the examiner and the controller, then the patent will be granted. So the time period for the, I mean, the lifetime of the patent, grant patent is the 20 years from the filing date. So every year after grant, every year the patent right should be renewed. In case the applicant fails to renew the patent, then the patent will be seized. So these are the quick steps in patent filing. Moving on to the next slide. Yes, now let's take a look at a few recent patent grant filed by college students. First one, as you can see, is a invention related to pneumatic quadrap robot filed by Mufakam College of Engineering. So this patent deals with the method of preventing falls or accidents via the quadrap robot. Moving on to the next slide. So another example is polymer composition for packing food materials filed by Krishnamal College of Women. So this deals with the process of preparing a degradable polymer sheet for packing food materials without adding any chemical. So these are few recent grants filed by college students. So moving on to the next slide. So let us take a look on a few interesting inventions. Few of you, the first invention, few of you might come across this year, I mean, this news in 2020, where a 14-year-old girl from Trivanamalai innovated a solar-powered mobile ironing cart. So the invention deals with a solar panel, which is normally fixed in roof. Actually the solar panel powers the steam iron box to recharge the battery and to supply power in the absence of sunlight. So the ironing cart can be fitted with the coin-operated PCO or USB charging points. The next invention is actually a smart mask, smart face mask actually. It is filed by a Japanese startup, Donut Robotics. This smart mask actually is invented to make communication and making social distancing easier. So by connecting with this app, the mask can transcribe dictation, and it can also amplify the wearer's voice, and it can translate speech into 8 different languages. So as you can see in the image, the cutouts on the mask, on the front of the mask are important for breathability. So actually it does not offer protection against coronavirus because it is designed to be worn as a standard face mask. So this mask is made of white plastic and silicone. It also has an embedded microphone, and it can be connected to the wearer's smartphone through Bluetooth. So this actually can translate between Japanese, Chinese, Korean, Indonesian, English, Spanish, and French. Yes, that's it for the session. Moving on to the next slide. So in case if you have any questions, please post in the chat box, or you can unmute yourself and ask your question. We'll be glad to answer them. Any questions? Okay. Maybe we have always our email ID. Okay, we have some question in chat box. After having some idea what is the next procedure and where we have to go for IPR. Okay. I mean, if you have some idea, the first step is actually to check for the idea whether it is patentable or not by doing a patentability search, which we do, which IB professionals do. So after knowing that your idea is really patentable, I mean, it satisfies the patentability criteria, then we have to go for filing the provisional application. Or as I already said, if your idea is fully developed, then we can go ahead with filing the complete specification. It can be filed through online. E-filing can be done through online. These are the few next steps after having the idea.
Jaya, one more thing I want to add to your answer.
Okay. Go ahead, Bhargavi.
If anybody has any idea, then first fix under which category your idea will come. Suppose you need, as we explained in the session, there are many types of IPR. So what type of protection you want? First, what is your idea is about, and you can roughly check under which IPR it will fall. So suppose if it is a design like thing, means you cannot go and so much get into patent and all, wasting your time. So if it is more something related, your idea is something related to ornamental design or like that, you can go for industrial design. If your idea is more technical and it is giving a solution, means then definitely you can go for patent. So before having once you have some idea, first make sure that your idea comes under which category, then it will be easy for you to choose which type of IPR protection you want. That's one thing I want to add.
Okay. Any other questions? Yes, thank you.
Thank you, team.
Okay. No, ma'am. We can go ahead. These are actually these are our contact details. You can, if in case of any questions, you can always reach us through the mail ID or you can call us. Yeah. Okay. Thank you. Thank you. Thank you, ma'am.
Thank you, ma'am. Thank you, everybody.
Thank you, everyone.